so honored to be invited to participate in this conference in the company of so many distinguished speakers on a topic that is so important today. I'm delighted to welcome everyone to this first session of the conference. It focuses on corporate legal rights and democracy. If you've logged into our webinar conference and you can hear my voice and you can see me waving on the screen, chances are you're a person. When I agreed to participate in this conference, I assumed that all of the speakers and audience members would be persons, that is, human beings, actual flesh and blood people. You might be a professor or a student, maybe a business executive, an activist, or any other person who's interested in the role of corporations in our society today. One thing I bet you are not, though, is a large corporation. Yet corporations are people too, according to the law. Corporations as legal persons can enter into contracts, they can buy and sell property, they can sue and be sued, and they can make claims to some of the most fundamental legal rights that are guaranteed to all persons under the United States Constitution. The corporation's not a flesh and blood person, but over time, the law has evolved to treat corporations in much the same manner as human persons when it comes to legal rights. And corporations have used those rights to gain advantages and to exercise power, both economically and politically. So how can this be? What does it mean to say that the corporation is a legal person that's entitled to fundamental legal rights? I mean, the word corporation doesn't appear anywhere in the US Constitution. So how have corporations been able to gain so many important rights? And what does it mean to say that the corporation has these rights? And how can we justify the continued expansion of corporate rights over the last several decades? Have we gone too far in empowering corporations with legal rights? And if we have gone too far, then are there reforms or retractions that might be needed to try to rein in corporate power and influence and strike the appropriate balance between the rights of individuals and then those of large corporate conglomerates? These are all very complicated questions, and we're going to try to address them at least in some measure in this session this morning. So we have two widely recognized experts in constitutional law and corporate law who will share their insights with us. We have Professor Adam Winkler, who is the Connell Professor of Law at UCLA Law School. Professor Winkler is the author of the recent book, We the Corporations, How American Businesses Won Their Civil Rights. That book was a finalist for the National Book Award for Nonfiction. And if you have not read it yet, I highly recommend it. I can say personally that it was one of the most illuminating and engaging, compelling books on legal history I personally have ever read. Professor Winkler has numerous book chapters and articles on topics involving constitutional law, corporate law, campaign finance law, and legal history. He's also ranked as one of the 20 most cited legal scholars in judicial opinions, including some landmark Supreme Court opinions on the First and Second Amendments. He serves on the board of the American Constitution Society, and many of you may recognize him as a frequent commentator on legal issues on some mainstream media channels. We're also very fortunate to have with us Professor Elizabeth Pullman, who is a professor of law and the co-director of the Institute for Law and Economics at the University of Pennsylvania Law School. Professor Pullman is the co-author of the corporate law textbook, Business Organizations, A Contemporary Approach. She's also the co-editor of the forthcoming book, Research Handbook on Corporate Purpose and Personhood. Professor Pullman is a prolific scholar who's widely recognized for her expertise on corporate constitutional personhood, corporate governance, corporate disobedience, corporate personhood, and corporate social responsibility, not to mention entrepreneurship and startup governance as well. She's previously taught at Loyola Law School in Los Angeles, and she's also served as a visiting professor at the University of Sydney Law School and UC Berkeley School of Law. Professor Pullman serves on the Corporate Laws Committee of the American Bar Association, and she's also served as a member of the Association of American Law Schools Business Association's Executive Committee. So thank you both very much for being our distinguished panelists. We're really looking forward to hearing your remarks. And we will start with Professor Adam Winkler.
Well, thank you so much. I'd just like to begin with thanks to Professor Ahmadi, the Stanford Business and Law Schools, and of course my fellow panelists, Susanna, Ripken, and Elizabeth Pollman. It's a special pleasure to be on a panel with Professors Ripken and Pullman, two excellent scholars who've taught me so much about corporate rights and corporate personhood over the years. In my just initial few minutes of remarks, I'd like to make 3 points. First, that although the topic of corporate rights recently rose to prominence as a result of Supreme Court cases like Citizens United and Hobby Lobby, corporations have been recognized to have fundamental rights under the Constitution really since America's earliest days. This is not a new phenomenon. Second, I wish to suggest that corporate personhood has not played the major influential role in the expansion of corporate rights that some activists and others believe. And my third point is that we should reject calls to eliminate all corporate rights, that while some cases do give corporations greater rights than they should have, some corporations need at least some rights to protect our democracy and our economy. So the first point, corporations have been recognized to have constitutional rights, just like individuals, for a very long time. The first Supreme Court case to explicitly address whether business corporations had rights under the Constitution was a case called Bank of the United States versus DeVoe. And that was decided all the way back in 1809. To put that in some perspective, the first Supreme Court case to specifically and explicitly ask whether African Americans had rights under the Constitution, the Dred Scott case, wasn't decided until 1857. And that the first Supreme Court case to explicitly ask about the rights of women under the Constitution, Bradwell versus Illinois, was not decided until 1873. Both these cases a half century effectively after the first corporate rights case in the Supreme Court. And unlike racial minorities and women who lost their first cases, and indeed lost most of their cases in the Supreme Court up until the mid-20th century, corporations, the corporation involved in that first Supreme Court case, Bank of the United States versus DeVoe, won that case, and corporations have been winning their cases pretty frequently and regularly ever since. That case I mentioned, DeVoe, it extended to corporations the right to sue in federal court under diversity jurisdiction. And since then, corporations have won Supreme Court cases extending them a wide variety of fundamental rights under the Constitution: freedom of speech, freedom of the press, due process, equal protection, the right to be free from unreasonable searches and seizures, the right to counsel, the right against double jeopardy, among others. Indeed, as I argued in my book, that Susanna very kindly complimented, I greatly appreciate those generous words, we the corporations, that the corporate rights movement could be thought of to be really one of the most successful yet least well-known civil rights movements in American history. Now, I wish to suggest that while the corporations have been extended a wide variety of constitutional rights, corporate personhood has not been the reason or really the linchpin of that movement. Now, corporate personhood, just for background, most of you already know this, of course, but corporate personhood is the idea that a corporation is a distinct legal entity in the eyes of the law, separate and apart from the people who constitute the corporation. So corporate personhood means that when a corporation acts, it is that legal entity that is responsible for those actions, and not the shareholders or other stakeholders. So if you slip and fall at Starbucks, you have to sue the corporate entity, not the individual shareholders who happen to own a piece of Starbucks. Now, corporate personhood is a really ancient idea. Blackstone in 1757 in his commentaries on the law of England described the corporation as, quote, an artificial person. And it remains one of the very basic foundational rules of modern American corporate law, that a corporation is a fictional entity separate and distinct from its members, with many of the rights of ordinary people, such as the right to have property in its own name, the right to form contracts in its own name, and the right to sue and be sued in its own name, not the name of its members. Yet corporations have won their rights in the Supreme Court without corporate personhood playing a really influential role. Indeed, many of the Supreme Court cases extending rights to corporations have said that corporations have rights in order to secure the rights of their members. Take the DeVoe case that I began with. Chief Justice John Marshall in that case said that corporations have the right to sue in federal court, not because corporations were people, but because corporations were made up of people. That corporations were essentially associations of people, and that those people who make up the corporation have the right to sue in federal court. So even though the Bank of the United States' lawsuit in that case was brought in the name of the corporation to recover the corporation's property, Marshall said that, quote, essentially the parties in such a case are the members of the corporation. Now, Justice Samuel Alito's opinion for the court in the recent Hobby Lobby case takes a very similar approach. In that case, Justice Alito's majority opinion argues that the birth control requirement that the court said could not be imposed on Hobby Lobby burdened the religious liberty of Hobby Lobby's owners, the Green family. The court didn't say that Hobby Lobby was a religious entity, but Hobby Lobby's religious freedom needed to be protected in order to protect the religious liberty rights of the Green family. Now, in these cases, the Supreme Court is rejecting the core tenet of corporate personhood, that corporations and their members are separate legal persons with separate and distinct rights and responsibilities. Indeed, if a corporation's rights are derived directly from its members, who are themselves generally people, then really it's little wonder that corporations have nearly all the same rights as people. My final point is that corporations, at least some corporations, should be recognized to have at least some rights under the Constitution. To date, about 19 states have endorsed a constitutional amendment to declare that corporations have no rights under the Constitution, and that the rights in the Constitution are reserved for natural persons. But if corporations have no rights, then the government could seize their buildings to build a freeway without paying just compensation, as the Fifth Amendment requires. If corporations have no rights, then a President Trump, angry at the New York Times or CNN, could censor those corporations because they are indeed corporations. And if they have no rights, then those corporations have no protection against censorship for their speech. Moreover, not all corporations are business corporations. Many religious organizations are organized as corporations. Many nonprofit advocacy groups like the ACLU and the NAACP are organized as corporations. If we eliminate corporate rights entirely, then these organizations could be shut down. And that seems to be a serious mistake, I think. So I think we should resist calls for eliminating all corporate rights and instead think critically about which rights should corporations have. I think one way that we can at least begin that conversation, I don't think that's the end of the conversation, but the beginning of the conversation, is to look at a move that the Supreme Court made back in the Lochner era. Lochner era, remember, a very famous period in the Supreme Court's history where the court was very, very business friendly, struck down a lot of laws that regulated business. And even though that was a business-friendly court, that was actually quite inundated with claims for corporate constitutional protections, the court said that corporations didn't have all the rights under the Constitution. Rather, the court drew a line between what it said were property rights, which corporations should have, and liberty rights, rights that are associated with personal conscience or political freedom, that the Supreme Court said are the kinds of rights that belong only to natural persons. Again, I don't think that's the line that we should ultimately draw, but I think that what we should begin when we think about different corporations and different kinds of rights is to start with that presumption. The presumption that corporations have property rights. If they don't, people won't invest in them, and the corporations will not be effective for our economy. But that corporations, we should presume, should not have liberty rights, such as things like political freedom or a fundamental right of privacy. Again, those are just presumptions, and I think that when we get into a longer conversation, we can look at whether different corporations should have liberty rights and other corporations should not have liberty rights, depending on the type of corporation that they are. But I think that begins us with at least a kernel of an idea to help begin the process of separating which rights corporations should have and which rights corporations should not have. Thank you.
Thank you very much, Professor Winkler, for those introductory remarks. You've set the stage with several important points regarding corporate rights that we definitely want to explore in more depth when we get to the discussion portion of our session. But now we are very eager to hear the remarks of Professor Elizabeth Pullman, who will also share her perspectives on the topic. Professor Pullman.
Thanks so much. I'd like to make a few preliminary points and also express my warm thanks to Professor Ahmadi and our organizers and my fellow panelists. The preliminary points that I'd like to make are about the types of issues related to corporate personality or corporate personhood that can arise, the history of corporate rights, and then the present challenges, to give some context from my perspective. So the first is about thinking about the different types of issues related to the corporation as a legal person, to provide some contextual clarity. So the first issue is about the entity status of corporations under the law, or what we might call legal personality. It's what Professor Winkler just referred to as corporate personhood. It's the idea that when a corporate charter is granted, the law immediately recognizes the existence of a new legal entity, a new person that's separate from the organizers and investors, an entity that can carry out certain activities, perhaps even business activities, as this legal person. And that concept is core to what corporations are and what they're able to do. And it was established long before the question arose as to how to treat corporations under the US Constitution. That separate legal personality of a corporation, it evolved out of laws and practices in Europe, such as during the Middle Ages, concerning churches and universities. And it evolved into a practice of allowing legal status as a corporation to be granted by the Crown or Parliament to municipalities, religious institutions, charitable organizations, colonies, and trading companies. And by at least the 18th century, English law had established corporations as not only having this separate legal personality, but as having certain abilities to act under the law. And this flowed from the common law interpretations, including the ability to contract and to own property and sue and be sued in the corporate name. And at early American law, these were recognized as well, and it was understood that the states had the power to grant the charters, and then those would be incidental powers under common law. It was also understood that corporations could have perpetual existence, which was a very different thing than existed for partnerships, for example. And limited liability for corporate shareholders developed over time. So those entity characteristics or abilities of the corporation, they've existed for long before the US, and they were crucial to establishing the usefulness of the corporate form for raising capital from a broad group of investors and building lasting institutions. And that corporate power and the corporate form and its incidental powers, it's just been enormously important for developing the infrastructure and growth of our country, and it continues to be of incalculable value, the legal personality of corporations. Second, there's an issue of statutory issues, of whether corporations are intended to be included when a statute refers to persons or people or the like. Statutory laws, both state and federal, they'll often include corporations in their definition sections to make clear that the statute applies to corporations. But when they don't expressly include corporations in their language or define person to include corporations, it can give rise to ambiguity that eventually has to be interpreted by courts. So for example, in FCC versus AT&T in 2011, the Supreme Court had to interpret whether corporations have a right of personal privacy for purposes of the Freedom of Information Act's Section 7C exemption, and the court concluded they don't. And in Burwell versus Hobby Lobby in 2014, the Supreme Court interpreted whether a business corporation constitutes a, quote, person who can exercise religion under the Religious Freedom Restoration Act, and concluded that it can. And then third, there's the issue of the treatment of corporations under the US Constitution. And as Professor Ripken said, the Constitution doesn't specifically mention corporations. So as a matter of constitutional text, there's no explanation about whether the term person or the people or citizens includes corporations. But despite that lack of reference to corporations, as Professor Winkler mentioned, for over 200 years, the court has recognized that corporations can be the subject of constitutional protection or holders of rights. And that's what I would refer to as the doctrine of corporate personhood. And it recognizes that the corporation itself could hold that right. And the Supreme Court in that 200 plus years has recognized that, but it has never broadly ruled that corporations are entitled to all of the constitutional rights and protections that individuals enjoy or coextensive with individual rights and protections. And courts over time have used different points of reasoning to try to get to those determinations. But the Supreme Court has never developed a consistent test or approach to these corporate rights determinations. At times, people in courts have tried to reason from the idea of the nature of the corporation to try to determine what rights it would hold. And answers to those types of questions have often circled around three different concepts. First, the corporation as a concession of the state, an artificial being or creation under the law that only has whatever powers are conferred. Second, an aggregation of persons or an association. And then third, imagining the corporation as a real entity or greater than the sum of its parts that could have its own separate existence in a sense. And each of those concepts or descriptions, and sometimes more than one, appear in many opinions determining corporate rights. And then the next point I want to move on to is just to give some context about that corporate history that Professor Winkler started to delve into. So as he mentioned, the first case that went to the US Supreme Court was in 1809, the United States, Bank of the United States versus DeVoe case, which was about diversity jurisdiction. And that had to be interpreted because Article 3 and the Judiciary Act of 1789 provide that the federal judiciary may hear cases or controversies between citizens of different states. So it's not clear if corporations would be part of that. And the court observed that the mere legal entity, a corporation aggregate, certainly isn't a citizen. But then it was willing to look to English common law precedents for the notion of looking to the members composing the corporation and to extend that principle to determine whether there could be complete diversity of state citizenship with regard to corporations. And the next early cases concerning corporate constitutional rights involved contract and property interests, such as the 1819 case of Dartmouth College, in which the Supreme Court recognized that corporations were protected by the contract clause of the Constitution. And again, the reasoning was to look at the corporate charter as a contract between the individuals who incorporated the entity and the state, and to then understand that it could grant the protection of the contract clause to protect the people that were behind the corporation. And so that the state could not unilaterally amend the charter of a private college and effectively convert it into a public institution. It was also in the 19th century that the Supreme Court established constitutional protection for property in other ways, allowing corporations to invoke the 14th Amendment due process protections, which comes from Santa Clara County versus Southern Pacific Railroad's famous head note, but also cases from around that time, like Pembina Mining, in which the Supreme Court said that under the designation of person for 14th Amendment, there's no doubt that a private corporation is included. Such corporations are merely associations of individuals united for a special purpose and permitted to do business under a particular name and have a succession of members without dissolution. So in the 19th century, if you step back and put that into perspective, the Supreme Court enabled corporations to access federal courts through diversity jurisdiction. It recognized corporations as having protections under the contract clause and the 14th and 5th Amendments in the context of guarding corporate property. But notably, if you look at it, there was also a number of instances during that period of the 19th century in which the court rejected claims to rights or constrained the breadth of its interpretations. In the DeVoe case, the court rejected the notion that the corporation itself was a citizen. One of the most lasting impacts of the Dartmouth College case was Justice Story's concurrence that highlighted the path for states to retain their power over their corporations by reserving power in the general incorporation statutes. In 1837, Charles River Bridge, the court ruled that a corporate charter that confers a privilege that wasn't open to the public, like a toll bridge franchise, should be strictly construed against the grantee in favor of preserving the public rights. And the Supreme Court repeatedly ruled that corporations aren't citizens for purposes of Article 4 and the 14th Amendment's Privileges or Immunities Clause. And even during that late 1800s cases involving railroads and the 14th Amendment, the court made clear that it didn't consider corporations to hold the same protections as natural persons and made a distinction between the liberty rights and the property protections. So when you step back and think about the 19th century case law, it was doing some very important work of recognizing corporations and their importance to do these sorts of things that were incidental powers to legal personality. And it extended those in a way that was very important to protect those as against the government as well. But it did it in a way that was balancing the power of corporations and often rejecting claims of corporate citizenship and power. And when you contrast that with the 20th century, you see, and later to today, you see a different trend. Once you turn towards the 20th century, you see that the court has significantly expanded corporate rights, and the court has not developed better ways at answering these questions. It's become perhaps less apt to reject claims to corporate rights, seemingly more willing to extend them, especially since the 1970s. And the size and complexity of business corporations has grown. And so right from the early part of the 1900s, we had the court starting to extend freedom of press and freedom of speech to protect newspaper corporations. During the mid-century civil rights era, as Professor Winkler mentioned, the court started to recognize things like freedom of association for the NAACP, a nonprofit membership corporation. But by the later part of the 1900s, the corporations started to get bolder with claims for liberty rights and expressive rights, and started wielding those earlier precedents to expand rights for all corporations. So that trend in many ways culminated in the 2010 decision of Citizens United, in which the court granted corporate political spending rights to all corporations, not only political advocacy organizations like the one that brought the case. And to conclude these preliminary remarks, I would agree with Professor Winkler that really where the action is at is figuring out the line drawing between which corporations get which rights. Because there's a broad spectrum of corporations, municipal, that is cities and other localities that are incorporated, nonprofit or charitable organizations and businesses. And even within the business corporation realm, we can observe a wide spectrum. And then there's a wide range of rights. And so the courts have often acknowledged that corporations aren't the same thing as the people behind them, but then at the same time, often simultaneously displaying a willingness to treat them that way. And once the court starts to reason in that direction, it tends to grant rights because it sees people in front of it, natural persons behind the corporations. So resolving that analytical challenge of line drawing is just difficult and contestable. And I think we should get into some of those questions in our discussion. So I'll stop here. Thank you so much.
Thank you very much, Professor Pullman, for your very helpful explanation of the different issues that are related to the corporation as a legal person. I do want to spend a little bit of time asking you and Professor Winkler maybe a question or two with regard to the remarks that you made, and then we're going to open it up to questions from the audience. So I just want to pause briefly to remind our audience members that if you do want to ask our panelists a question, please feel free to type your question into the Q&A feature, and then Professors Pullman and Winkler will try to address as many of the questions coming in from you as they can. One of the things that I was thinking about as the two of you were talking, because both of you kind of raised, what all the action that occurred in the 19th century and how we've had these corporate rights for a very long time, and just thinking about explanations for how corporations have gained greater rights over time. Have you sort of thought about this in terms of the way things have shifted in the manner in which the law has traditionally viewed corporations? I mean, initially, in the early 19th century, you had special chartering where the legislatures would give charters and authority to business to incorporate for very special individual case-by-case reasons that related to a public function, like a corporation that wanted to build a bridge or a canal or provide transportation services or public utilities. So there was really this sort of public benefit or welfare aspect of authorizing a business to incorporate. And then that kind of shifted, didn't it, later in the 19th century when we moved to more general incorporation statutes where anyone, anywhere can form a corporation for any reason that they want as long as they file a set of articles of incorporation with the state. And that's the system that we have today. In the prior system, Professor Pullman, you mentioned it was sort of this concession theory, this idea that the government was giving a concession to a business, a gift to a business to give it the authority to exist and to perform its sort of public function. And we've moved away from that, haven't we, to sort of look at corporations more as being a form of private property, not so much a tool or extension of the state to perform a public purpose, but the private property of the individuals who freely can incorporate for any reason that they want. And once you make that transition, doesn't that then trigger all of these deeply revered beliefs we have about private property, you know, that we so fiercely want to defend our private property rights? God help you if you mess with my private property or impede the use of, you know, my private property. So that seems to me to make it a little harder to impose regulations on corporations and to sort of burden them with limits. As previously and under that old approach, state governments could limit how large corporations could become, how long they could exist, you know, how much some corporations could even charge, you know, prices to customers, et cetera. Now that would sort of be unthinkable because we see corporations as being the result of private contracting and we've got private property rights that protect those. So it makes it sort of easier then to extend rights to corporations. I wonder if you think that that's part of the explanation for why corporations have gained greater rights over time, and has it been sort of a shift in the way that we view what the corporation is and what its relation to the government is? Any comments on that?
I have an initial thought. I'm also curious to hear what Professor Winkler thinks. My initial thought is that in many ways, I would say no. And in fact, when you look at the history of general incorporation statutes, for example, as you mentioned, that was in many ways a reflection of some of these same themes that we're struggling with. That when you look back through history, the relationship between corporations and American democracy has always been complicated, and people have almost always been aware, at least some people, of those questions and the difficulties. And so, for example, the general incorporation statutes in part came about because they were a solution to a political problem that had arisen with elites constraining access to corporate charters to other elites that were part of their political party or part of their social network, and to people who had the ability to go to state legislatures and ask for special acts. And so opening it up was, in a sense, a form of democratizing and solving that political problem. But then, of course, as changing views arise, then we started to think about corporations and corporate statutes in more of an enabling way. And so in that regard, I understand the nature of the question, but I also think even when you look back to the reasoning of the cases over 200 years, in many ways, the current cases do some similar things as the past cases. And that's, in my view, part of the problem, that as the history of business corporations in particular changed and the spectrum of business corporations changed, we have not come up with actually much better ways of dealing with that. And instead, what we've ended up with is corporations that are more empowered by rights, and in many ways, a number of larger corporations. And so it's just a different balance, but it isn't actually a different theme or understanding in many ways.
Okay, thank you. Professor Winkler, did you want to add to that too?
Yeah, I generally agree with Elizabeth's point right along the line that, yeah, the corporation in corporate law has changed, and we do think about corporations differently. It hasn't necessarily had a huge impact on the corporate constitutional rights question, in part because the Supreme Court was extending corporations' constitutional rights before that idea that the corporation is just a private entity, a private contractual relationship among different stakeholders. And in part because the Supreme Court is adopted what we might think of the contractual model of the corporation in some ways in its constitutional rulings long before general incorporation really took off. Professor Pullman mentioned the legendary Dartmouth College case, which didn't involve a business corporation, of course, but did involve a corporation. Dartmouth College was organized as a corporate entity. As Professor Ripken, as you asked, as you mentioned, corporations were originally thought of as quasi-public entities. You needed special permission from the government to create a corporation, and every corporation had to have a public purpose built into its charter. But the Supreme Court really changed that in terms of at least constitutional reasoning in that Dartmouth College case all the way back in 1819, when legendary lawyer Daniel Webster, considered one of the greatest advocates in the history of the Supreme Court, won that case for the Dartmouth College. And in that case, Chief Justice John Marshall, who also wrote the DeVoe case that we mentioned earlier, Marshall really discounted the public purpose side of the corporation. Dartmouth, Marshall said, was not really created by the government, the Chief Justice wrote. He said it was really endowed by private individuals who had bestowed their funds for the propagation of the Christian religion. The government, in that case, Marshall noted, had not given any money or assets to fund the college. As a result, the court said that when we think about the public purposes of a corporation, the public purposes are not special purposes that are added on to the private purposes of the investors, but rather the public purpose in a modern in an American corporation, in Chief Justice Marshall's view, was merely the accomplishment of the private purposes that the individuals had organized the corporation for. In that case, it was the promotion of religion and education. And the court said those are just generally beneficial for the country in general. And that the court said, quote, that the benefit to the public is considered as ample compensation for the faculty incorporation in that Dartmouth College case. So we haven't really seen that shift, in part because the Supreme Court adopted that earlier theory back in the day. But certainly as corporate law changes and as we come to see corporations more and more as mere contractual entities and contractual devices or a nexus of contracts, if you will, it does make it that much harder to think about the corporation as its own separate person with its own distinct rights and responsibilities, rather than just sort of the associated rights of those who gather within the corporation.
Great. Thank you so much to both of you for helping to clarify that. I do see that there are a number of questions coming in from the audience, so I want to devote enough time in our session to that. This first question is directed to Professor Winkler. The audience member mentioned, Professor Winkler, that you differentiated between property rights and liberty rights. Would it be useful to differentiate slightly more between property rights, liberty rights, and political participation rights? We might want corporations generally to hold liberty rights, speech, for example, but not political participation rights. How do you feel about that distinction, Professor Winkler?
Yeah, no, that's a helpful way of adding a sort of another dimension to it. Generally, when the court thought about liberty rights, it was referring in part to political rights, those rights to be active politically. There were court cases back in the early 1900s that said corporations don't have a right to spend their money on politics, the opposite of what Citizens United held years later, in part because the idea of political participation was the kind of thing that was restricted to natural people, not artificial entities. But again, I think that what these lines are helpful lines to help us conceptualize the problem a bit. But again, they're not the conclusion. And I don't think drawing those lines too harshly really makes a lot of sense. There are for-profit corporations that should have some political participation rights. If by that we include, say, newspaper corporations endorsing candidates. That's something that we have had for a long time, that newspapers take out editorials in favor of candidates. That's political participation in a way. It's not the right to vote. But even if we're talking about the right to vote, there are some jurisdictions in America, such as water districts, where the right to vote is based on how much land you have in the water district. And often corporations are owners of land in that water district. And generally courts have said, well, in that context, corporations should have the right to vote, just like any other landowner that's affected by that district should have the right to vote. Now, I don't think that we should have Microsoft exercising the right to vote, although I might note that if Microsoft exercised the right to vote but didn't spend money on politics, it would probably be better for American politics, because there's only one, they only have one vote, but they have a lot of money. And so where corporations really, where corporations really overwhelm us in political participation is not whether they have the right to vote or not. It's because they can spend their money on politics on an equal basis as ordinary individuals. That's Citizens United. Goes back a little bit probably to Buckley as well. But that's really the issue that creates a much different political emphasis in terms of political power, because the corporations can have much more money than you and I have. If they only had one vote but couldn't spend all their money, it might be a move in the right direction.
Professor Pollman, did you want to add any comments to that as well?
I think going back to my earlier remarks, I think there's really two things to keep in mind. One is the type of right, and then the other is the type of corporation. And so I think that's the way to provide some conceptual clarity to thinking through the issues. And so you could start from, in a sense, like the basic protections, like contract and property and those sorts of things. And we could understand that those could be granted to all corporations. But as you're moving along different types of rights, like moving into expressive rights, which you may refer to as liberty, which is actually, I think, a broader term. But once you get into those, it'll start to matter a lot what type of corporation you're talking about. I think that in many ways is just as important as drilling down on thinking about the different aspects of expressive or political participation. So that's what I would add to the discussion.
Okay. Great, thank you. There's another question here for the two of you. You had both mentioned that in many situations, the Supreme Court has given rights to corporations really to protect the owners of the company or the people behind the corporate structure itself. And this question says, if I understand correctly, you subscribe to the view that corporate rights represent the rights of the people who compose them. And you suggest that these people, of course, are natural people. But for many multinational entities, that isn't the case, especially if we consider the issue of controlling shareholders. So for many large corporations, controlling shareholders are institutional investors or other legal persons. So do you agree, or are we mistaken in that characteristic, that characterization? And then if you do agree, should we be thinking about a different categorical approach to corporate rights rather than speaking of corporate rights as if corporations just in general should or should not have certain rights? Shouldn't we break up the corporations into different categories? And I think both of you have sort of suggested that, right, in terms of their size, their purpose, their governance structure, whether or not they're for-profit or nonprofit, etc. So your thoughts on that question?
Yeah, I would first try to make clear that as we were discussing the idea that the Supreme Court has granted rights on a rationale or basis of understanding that doing so would protect natural persons, it was simply that point that I was trying to make. I wasn't asserting a normative view in a sense, because if you think about it, corporations, it's like turtles all the way down. Eventually you get to natural persons. And Margaret Blair at Vanderbilt, who I've co-authored with, wrote a really nice essay that looks at different types of corporations, like even special purpose entities and just holding companies, in which you could say, well, that type of corporate entity has separateness, and there actually isn't a natural person that's involved in that holding company or special purpose entity that may just be a shell. But in a sense, if you think all the way down to the bottom turtle, there was a natural person that was involved in setting up the structure, and they had a certain purpose, et cetera. And so it would be possible, at least for the Supreme Court, to reason in the same way that it had as to other types of corporations. And that's where I think there's quite a bit of danger in not recognizing that spectrum of corporations, and especially with regards to certain types of rights, like expressive rights, where you may not be able to find any natural person that's involved in the type of way that would actually be necessary to protect their rights. And the reason why I think that's dangerous in a sense is because there's competing interests in society from other natural persons whose ability to fully express those and participate may be impinged by that grant.
Mhm. And Professor Winkler, any thoughts?
Yeah, I would just concur with Professor Pullman. Just to emphasize once again, I was not endorsing the view that corporations should have rights because their members have rights. I think it's actually a much more complicated question than that. Merely just meant to, as I think Professor Pullman was too, to describe how the court has justified the move towards corporate rights rather than for us to personally endorse it in that case. I actually think it would be more helpful if the Supreme Court were to treat corporations as people. That is to say that the corporation is its own separate and legal distinct entity apart from its members, and its rights and responsibilities are different and distinct from those of its members. And if you look through American history, there have been occasions where the Supreme Court has embraced that principle of corporate personhood, said, let's look at the corporation as its own entity and not reduce its rights to the rights of its members. And strangely enough, the irony there is that in several of those cases, the Supreme Court has limited the rights of corporations, because when it's looked at the corporate person, it sees a fundamentally different kind of person than when we look at ordinary individuals. So in 1839, the Supreme Court, in a case dealing with privileges and immunities under Article 4 of the Constitution, said that was a case in which the Article 4 basically means that if you move from one state to another, you are entitled to all the same rights as a local person, a person in the state to which you've moved. And corporations in the 1830s, which were seeking to operate in the growing national economy, tried to use this provision to strike down and challenge state laws that imposed special requirements on out-of-state corporations. If you want to come and do business in our state, you had to do these special things. And the corporations challenged those laws, saying that, look, our members are citizens, and our members are citizens who are entitled to, by this Article 4 of the Constitution, to come into any state in that they want, to make contracts on the same terms as locals, and that corporations should be entitled to that same freedom. And in that case, the Supreme Court said, no, that there's a difference between the rights of the members and the rights of the corporation. According to the Supreme Court, in that case, the court said that a corporation is a person for certain purposes, and that when a corporation makes a contract, it is the contract of the legal entity, of the artificial being created by the charter, and not the contract of the individual members. By separating the corporate entity from the members, the court saw that the rights and duties of a corporation were distinct and different from those of the rights of the members. And we've seen that in other cases too. The Supreme Court in the early 1900s said corporations were not entitled to the right of self-incrimination under the Constitution. They couldn't stop their officers from being forced to testify against the corporation. Why? Because the court said that the legal rights and responsibilities of the officers as people are different and distinct than the legal rights of the corporation. And just as you can't say, I'm refusing to self-incriminate, but I'm refusing to testify against Professor Pullman because of my right of self-incrimination. It doesn't protect Professor Pullman. It protects me from me being incriminating myself. The court said, well, that's just like the officer testifying on behalf of the corporation or being forced to testify against the corporation. So I think that actually a corporate personhood might be a better starting point, in part because it focuses us on the questions that Professor Pullman says we should focus on. What is the nature of the corporation? What kind of corporation is it? What kind of right are we talking about? Rather than reducing it all to the members who are undifferentiated and are going to be often the same regardless of the type of corporation.
Great, thank you. There's one more question here, and I think we do have time for just another one in our Q&A for the audience. And then I do want to move to the next segment of our panel where we're going to invite some experts and other extended panelists and invited speakers to ask a few questions. But there is a question here from an audience member that asks, can't Congress simply pass statutes to give corporations the protections that they currently need? We're talking a lot about the constitutional aspects of the Supreme Court extending corporate rights to corporations. But this audience member is asking, well, can't we just sort of put this in the hands of Congress so that, for example, when it comes to the First Amendment and free speech rights, journalists as individuals could be protected by the First Amendment, but not their corporate employer. So we could have Congress just sort of make those rules for us rather than leaving it up to the Supreme Court to interpret whether or not constitutional law should apply to corporations as persons.
Well, that goes back to what I started with, in a sense, as I see it, which is understanding three different ways in which these issues can arise. And the first is just a basic understanding of legal personality and at common law, the powers that come with that. And then second is statutory issues of interpretation. And then third is constitutional interpretation. And so while Congress could try to grant protections to corporations, if doing so was consistent with the Constitution, that wouldn't change the fact that issues under the Constitution would still arise. And we have over 200 years of jurisprudence now interpreting it. So that's the challenge.
Yeah, and I'd say that, it's a nice idea that we could have Congress do it, but the problem is that there are some, if we leave it up to government to decide which rights corporations will have and will not have, it's very possible that we're going to lose the basic protections that we want corporations to have. When Donald Trump had control of the White House, Republicans had control of both houses of Congress, and President Trump was railing against CNN or the New York Times. I wouldn't want to rely on the good intentions of Congress to decide whether we could actually censor the New York Times or CNN. I mean, maybe it's far-fetched. Maybe they would never pass such a law. But I personally would be concerned. And if we look through the course of American history, what we do see is that indeed lawmakers have occasionally tried to censor corporations. Back in the 1920s and 30s, it was Huey Long in Louisiana who tried to censor the newspaper corporations that were opposing his agenda. Back in the late 1920s, early 1930s. Those cases led to landmark Supreme Court decisions protecting the freedom of the press. And similarly, if we want corporations to have secure property rights, then we really do need to give them and recognize that they have those property rights. Some of that stuff can be done through Congress. I think that would be great to protect some rights of corporations through legislation, provide some clarity, and I think the Supreme Court itself might be influenced by what Congress does and how Congress might shape those rights. But there is the concern that if Congress is only protecting those rights through statute, then those statutes can be revised whenever the political winds change, and that might hurt democracy as well.
Okay, well, thank you. These have been great comments and wonderful questions from the audience. And I do apologize that we were not able to get to all of the audience questions because we do now want to move to our last segment of our session here, where we'll have an extended panel discussion with additional experts and invited speakers who also have some comments and questions. So I'd like to start with Stanford Law School Dean Jenny Martinez, who has a question about comparative law. Dean Martinez, would you like to turn on your camera and your mic and join us on screen to make your comments?
Yes, thank you so much. And thank you to the panelists for just a really fascinating discussion. I wondered, since a lot of what you've talked about has focused on the United States, and obviously the issue of the relationship between corporations and the rest of society and the way in which their rights and responsibilities are treated is one that's shared by most countries in the world. If you could talk a little bit about the comparative law aspects of these questions and the degree to which the choices that the United States has made in its legal system are typical of many other countries or idiosyncratic in certain respects. I know that in other parts of the world, there are sometimes different conceptions of the relationship between government and markets, or between the corporation and its shareholders and other stakeholders in the corporation, such as employees or consumers, and just different ways of conceptualizing these things. And so I wonder if you could talk a little bit about the comparative law aspects of the questions.
Sure, I can jump in here if you'd like. Thanks so much, Dean Martinez, for organizing the conference and for a great question. I haven't done extensive research, all the different ways in which corporations are thought of in different countries. But what we do find is that notions of corporate personhood are pretty standard, right? The idea that a corporation is a person with rights and responsibilities, legal rights and responsibilities distinct from those of its members, is pretty widespread among what we might think of as industrialized nations that have the kind of advanced corporate law that we would be familiar with. So that itself is not so unusual. And indeed, we can find, if we look in other countries, there's not a lot of controversy over whether corporations have property rights, for instance, or have the right to sue and be sued, or the right to form contracts. That's sort of a core basic set of rights that Professor Pollman said we might recognize all corporations to have. Two big differences is one is we don't see in a lot of other countries corporations being extended some of the rights that corporations have more recently gained in the United States, such as a right to make political expenditures or a right to religious liberty. We just don't see those moves in those other countries. So that does speak to something that is distinct in the United States. We might say that that is in part because some of those questions are more commonly and more likely fed as constitutional questions in the United States, because we have everything ultimately decided by the Constitution, and most countries don't have everything decided by the Constitution. Some of those problems don't arise in quite the same way, but at least when we don't see other countries, other industrialized countries saying corporations have a right to spend their money on politics in the way that we have in Citizens United, or a right on the basis of religion to refuse to follow what are thought to be generally applicable laws that bind other businesses.
I agree. And I think the First Amendment is where you really see this divergence. And one topic that we haven't discussed is commercial speech and relatedly compelled speech that's been arising in recent decisions under US law. And that's quite different than what you see in some other countries. And it raises issues about the ability in the US to regulate corporations' disclosures in a way that I think is really an issue to keep watching in the US, because it is different than in other countries. And the other point that I would make is simply that because corporate governance systems are different, that not only does the First Amendment kind of questions play out differently in the US because it's an American provision in our Constitution, but not only that, but because corporate governance varies in systems across the world, sometimes in the US, the way that the constitutional issue comes up is that it's interacting with state corporate law under the US, such that, for example, like in Bilotti or Citizens United, the argument of the government was to allow for Congress to regulate the political spending of corporations, in part because it would protect the dissenting shareholders in the corporation. And the Supreme Court has responded to that in both instances by saying, well, we have the procedures of corporate democracy to alleviate that concern. And what it's referring to there is state corporate law in the US. And that's different around the world, how US corporate law at the state level in particular balances different stakeholder interests. And so not only do we have differences in the US Constitution and its approach, but we also have differences that are going on at the state corporate law level. And that also affects what we end up with.
Right, thank you. I'd also like to recognize Martin Wolf, who is from the Financial Times. I think Mr. Wolf also has a view with regard to sort of international corporate rights. And Mr. Wolf, would you like to turn on your microphone and ask your question?
I was actually going to ask, sorry, to start with, can you see me now?
Yes.
I was going to ask exactly the same question about, because the discussion was very, very American. And I have to say that, no, of course, America is the most important capitalist country, so I don't think that's in any way unimportant or far from it. I was going to just make a comment that, at least from my perspective, because Britain is notoriously free of constitution, I don't really feel that we're in vastly greater danger of having a government which takes away all corporations, corporate property than you do, but let's see how that plays out. But I do have a question, which is a bigger one, and probably maybe as lawyers, you will feel you've got to run away from this, which is fine. But it's what interests me. The way I think about this problem in the context of this whole series of lectures, of discussions in this conference, it's about the corporation and democracy. And to me, from my perspective, we have developed, not intentionally, a classic version of what I was taught when I was a child to think of as the overmighty subject problem, which is we have entities within our society, they used to be feudal lords, which are so powerful in terms of their resources, the whole range of resources at their disposal, that a normal democratic process simply cannot work. And I can see this in many areas of law, intellectual property law, there are many, many examples. Do you recognize that as a problem? And if you do, because corporations are, to put it very simply, in their role as politically influential entities, quite extraordinary in their resources. And if it is a problem within the American political and constitutional context, what on earth can you do about it?
Professor Pullman, would you like to get us started with your response?
Sure. I have so many thoughts, it's hard to narrow them down to a concise little nugget. But I would say that, I guess 2 points. One is that as you were discussing this, I think that, it's kind of like de Tocqueville, like we've had associations and intermediaries in society for a long time. And that can play a very helpful role as against the government in some instances. And in my own work, I've thought sometimes about how that might be. For example, I wrote a piece about whether corporations should have privacy rights. And on the one hand, in some contexts, that could be very troubling because of the power that the corporations have and how that would affect society. On the other hand, you could see that in some instances, corporations could play a very useful role for people as against the government in protecting individual concerns in a way that they might not be able to vindicate on their own. And so we have this dual nature to what corporations can do because of the power that they wield, and also the protection that that can provide as against the government. So in a sense, the fact that they are these intermediary organizations in society offers both potentials. And it goes to the second point that I would make about your big picture question about corporations and democracy. And I would say, yes, I think we're at a point where the balance of power is concerning. And what can we do about that is a really hard one. And I think that we've been on a trend, especially in the last 50 years, but especially in the 21st century, in which the Supreme Court has been very expansive in its interpretation of both constitutional and statutory issues granting rights in a way that it isn't tethered to specific corporations. And that's what I think is truly problematic in this discussion, at least as far as corporations and democracy. And that it's possible to reel that back in.
Professor Winkler, do you have a comment as well?
Sure. Well, I mean, I definitely agree with Martin Wolf about sort of the overwhelming nature of corporations in some spaces of American democracy and democracy outside of the United States as well. And I think the Supreme Court's just exacerbated those problems with a campaign finance philosophy that really views any restrictions on the use and spending of money as fundamental restrictions on freedom of speech. And this has allowed corporations to spend just an enormous amount of money on politics. And it's interesting because the court in the Citizens United case refers to corporations as disfavored associations, that they were subject to a kind of censorship and special restrictions that they shouldn't be, like almost like they were a discrete and insular minority needing the special protection of the Supreme Court. But because of the role that the marketplace plays in democratic market societies, corporations are always going to have a lot of political power because corporations are often the engines for economic growth and the creation of jobs and the creation of a tax base. And so even if corporations don't have the right to spend a lot of money, they're going to be pretty influential with government officials who want, for instance, the corporation to come to town and to bring a bunch of jobs. In the United States, we have a major problem where the states are fighting against one another to give ever increasing amounts of what we think of as corporate welfare, basically tax breaks, subsidies, all different kinds of special allowances that other businesses, other people don't have, just again to pursue economic growth. And so I do think that the court has, at least in the United States system, really gotten that balance wrong, and that we should recognize that corporations are, by their very nature in a democratic market society, going to have a lot of influence over government officials, no matter what, because they are those engines of economic growth.
Thank you. Thank you for your question, Mr. Wall. I'd also like to invite Professor Jennifer Taub on screen. She's a professor at Western New England School of Law. And Professor Taub, welcome. I think you wanted to ask a question about the line between government and the private sector corporations.
Yes, I think that's a very general comment. So let me zero in a bit on that. I apologize. I think I'm going to build off a little bit of what the journalist Martin Wolf from the FT said when he talked about when he mentioned feudalism. It makes me want to step back from this conversation and instead of just looking at this idea of which particular rights corporations should or shouldn't have, to step back and talk about corporatism, or maybe we want to say as capitalism, as a system of power. And once we frame it that way, I have a specific question. But before I do that, sorry, I really want to thank both Professors Pullman and Winkler for being here. I greatly admire your work. And in particular, and this goes to the private public comment, in particular, I appreciate that you look at corporation law in a public law context and not just a private law context. And for those of you who are not part of the Legal Academy, what you might not realize, this is very important, when we teach a class which is required at many law schools called either business associations or corporation law, it's very much about the rights and responsibilities of those inside of the corporation, right? The relationship between shareholders, corporate managers, and the board of directors. A class on corporation law has nothing to do with corporate finance. It has nothing to do with employment law. It has nothing to do, it's very rare that maybe you teach it and maybe I teach it, very rare that you would talk about corporate power or Citizens United or corporate political spending or anything. It's like the sealed off little space. And I'm not really sure why it's like that and why I continue to teach it that way. But this point that I'm making is there's a silo, and I know Anat want us to try to break those down. There's a silo and we can't get around it in our own thinking between corporate law as private law and thinking about public law, as well as when we think about government regulating corporations as if government itself isn't already at the highest levels in some way controlled by and selected by the most powerful. Where does that get to my question? I promise you there is one. In the context of corporatism as a power structure, do either of you have thoughts about my favorite new area, which is corporate lack of responsibility and accountability in the context of things like crime, money laundering, slides toward kleptocracy globally? This is very broad, so it's intended to allow you to say anything you want, including about the Nestle Cargill ATS case. So I'm leaving it very broad and mostly saying to you, I know this is a topic of the panel, it's about rights, but how can we talk about individual types of rights without the broader context of this idea of responsibility? Thank you, guys.
Why don't you start, Adam?
Sure, happy to go. So Thanks so much for such a wonderful question and a great point about some of the silos that we approach corporations with. And I think you're absolutely right. I mean, I think that there is something to be said about looking at corporate law and trying to expand what we think of as corporate law so that we might address some of these broader issues of corporate power and the relationship of a corporation to employees, investors, and a democratic populace more broadly. One of the problems is that corporate law used to include a lot of these concerns, but they slowly got sort of excluded and pushed out of what we think of as corporate law. I wrote a piece some years ago that Professor Fukuyama might appreciate. It was called "The End of History for Corporate Law," and basically said that there's this idea that corporate law has become all about shareholders and the nexus of contracts approach and all those other concerns about stakeholders or about how to treat employees or the broader public are all irrelevant. They're not part of corporate law anymore, and that's here for good. And it's important to recognize that although a lot of those, that the law still is very concerned with how corporations treat its employees, and the law is still very concerned with corporations and their place in a democratic society. But it just doesn't do that through corporate law. Now we have labor and employment law. Now we have consumer protection law. We have environmental law. All these things are fundamentally about regulating corporations and how they interact with others in society. But we've now taken them out. We've removed them from corporate law. There's something to be said about bringing them back in. Professor Pullman and Professor Ripken and I are all friends with Professor Kent Greenfield at Boston College Law School, who's written a very interesting book on this topic. And Professor Greenfield says, well, the issues of corporate rights would be less significant and less problematic if we had significant corporate law reform. That part of the problem is that corporate law has been so focused on the shareholder-centric, shareholder value maximization principle that if we revise corporate law, if we brought stakeholders into the board, for instance, and had them play a more fundamental role in shaping corporate behavior, then we'd have less reason to be concerned about some of these expansive corporate rights questions. But it's certainly the case that if we want to think about corporations in a democracy, it's not just about what kinds of regulations the democracy can put on corporations, but also thinking critically about corporate law and the internal organizational dynamics of a corporation and how those might be reformed to make corporations more responsible, more like good people rather than the bad people they seem to be.
The way I see it is similar, and I suppose I see a historical pattern that's been occurring that we're in the midst of. Since the 70s, there's been an expansion of corporate rights and also corporate lobbying in a very significant way. Since the 70s, there's been a shift in thinking about corporate governance towards shareholder orientation and primacy, not only in law, but in law, markets, and culture. And so those have been occurring at the same time. And meanwhile, we've had a diminishment of what Galbraith called the countervailing powers, things like unions, the enforcement of antitrust law, et cetera. So in many ways, I think this conference was just brilliantly designed to start by thinking about corporate rights, but of course, it's much broader. And that's, I think, part of what the conference is designed to get into, because we could understand that it isn't simply a narrow question about the corporate rights of, for example, political spending, but it's all of these things. It's that expansion of the rights and the use of them through lobbying and various other measures, a change in law, markets, and culture about how corporations are oriented, and then the diminishment of those countervailing powers. And so corporate law itself, for years, has been designed in a way that understood concerns about externalities and other stakeholders besides the shareholders and the board of directors to be kind of outside of corporate law, in that we could allow other areas of law to take care of those considerations. We can have employment law to worry about employees. We can have environmental law to worry about those externalities, et cetera. So corporate law itself hasn't done very much in the way of taking those into consideration or balancing them. But the problem with that has been in recent years that we can see that we can't just allow other areas of law to deal with that, because corporations themselves, I think you're getting at this in your question, have been able to use those historical trends of having more power and ability to use them, and orientation through law, markets, and culture towards shareholders, to use them in a way that's actually affecting our ability to do those other things outside of corporate law. And the former Chief Justice Leo Strine has written some great work in this area that helps us understand, I think, those historical patterns of these larger trends that we're in that do go beyond corporate rights.
Thank you very much, Professor Taub, for your question. Our first session here on this first day of the conference deals with corporate legal rights and democracy. But the very last session on the last day of our conference deals with corporate accountability and corporate obligations. So it ties in exactly with what Professor Taub was saying, that there's got to be this balance in the discussion about corporate rights as well as a corporate accountability. So stay tuned for that on the third day of our conference. Professor Luigi Zingales from University of Chicago, Booth School of Business, to ask a question about the financial view of corporations as a nexus of contracts. Professor Zingales, are you there?
Yes, I am. Thank you very much. I love the interdisciplinary nature of this conference, and so I love to learn also the mistake of my own profession. And this is finance has always been dominated by a contractarian view of the corporation, in which some of the issues discussed here are completely sidestep or ignore. And I think that, so the question I have is, once we recognize that basically the government, the state, gives some special extraordinary privilege to the corporation, the question is, what can the government ask in return for that? And in particular, I think that I like what Elizabeth was mentioning, the fact that maybe the rights of the corporation should be fine-tuned depending on what type of corporation you're running. In a sense, if you are running a political association, certain things are intrinsically important. If you run a for-profit corporation, not only these things might not be intrinsically important, but it might be a bit in contradiction. In a sense, as many have pointed out, if you are trying to maximize shareholders' value, you should lobby and do any basically legal bribing you can in order to distort the system. But it's a bit, from a social efficiency point of view, it's crazy that we endow this institution to have this disproportionate power to damage us collectively. So I think that, and I realize through the Jennifer Taub intervention that the finance problem is not just a finance problem, it's also within the law, that you have the separation between corporate law and private law and public law. But I think it's very important to bring all together and ask more broadly the question, how can we redesign the system in a way that is better for everybody?
Professor Pullman, you're nodding vigorously. Are you in agreement?
I just very much appreciated Professor Zingales' remarks, and I've also really liked his recent work. And going back to I think the beginning part of the question was in part about the nexus of contracts view of corporations. And I think it's interesting to observe that there's been different literatures that go back for a long time that have been separate literatures in a way, and they only intersect in part, and people sometimes assume they're the same thing. So sometimes, for example, people assume that the conception that exists in constitutional jurisprudence of a corporation as an aggregate, or the associational view, is in some sense the same as the nexus of contracts view that comes up in the finance literature. I've seen people make that move or assumption. And actually, when you read those literatures, they're very different at what they're trying to achieve. And so I appreciate Professor Zingales' remark, because I think a lot more work could be done to try to separate out when it matters that we're talking in a different context. Because when we're talking about constitutional rights, for example, that has implications about the ability to regulate and certain other considerations. Whereas if we might be talking about a financial theory from the finance literature, it may be trying to accomplish a totally different purpose. And so in some ways, I think it would be a very useful thing for us to have more conversations in which we determine when is it useful to think about these theories together and these literatures together, and in what ways are they just aimed at fundamentally different things. in some instances, such that we shouldn't import some ideas to another because they were expressed for a different purpose. And so it does come down at the end of the day, I think, very much to paying attention to the types of corporations and the types of questions we're asking too, if it's a question about finance or if it's a question about interpreting the Constitution.
Thank you. Professor Winkler, do you have one final comment?
Yeah, I'll just briefly add that, no, I think that's right. And just go to the how question. How do you go about separating out these different types of corporations? Well, I think probably the answer is through legislation and judicial doctrine, more than, say, in America, where there's a movement to amend the Constitution to address some of these questions. I don't think that's the particularly good way to do it, in part because these questions are complicated, that there's a lot of different variations on the theme, and that constitutions are better when they're not, prolix legal codes, but rather simple statements of principles and values. And so I don't think the amendment route is the way to go. In the American context, I think we can get there through judicial doctrine. If we had a Supreme Court that was open to these ideas, we don't, but if we had one, that would be a way to go about doing it. And in the absence of that, I think legislation, I think states should be active legislating what they think are the rights of different corporations at the state and at the federal level. Now, granted, because these are constitutional questions, there will be times when the courts reject those views that are articulated by other lawmakers. But I think part of the reason, part of the problem in this space of corporations gaining rights to have such a toehold in democracy is because the courts haven't thought really crisply and cleanly about this. There's not been a lot of other voices coming in to influence the court and how the court approaches these problems. And that I think that if lawmakers did take that opportunity to come up with, say, a statutory framework that would define those rights, while it might not be fully secure from judicial review itself, I think it would play a real influential role in shaping the judicial decisions that came out of judicial review when it was exercised, because there would be another group of informed lawmakers who are voicing their view on these issues. And so I think it's really important right now to really to have other legal entities step up and to try to sort of articulate some of the lines and create some boundaries.
Great. Well, this has been a terrific discussion of a very complex but extremely important topic. I wish we had more time to continue it, but I do want to thank our distinguished panelists, Professor Elizabeth Pullman and Professor Adam Winkler, for taking the time to share their expertise with us. And many thanks also to all of our additional experts and scholars who joined us on screen in the last segment to ask such important questions and give us their insights. This discussion has really laid a great foundation for the rest of the conference as we explore these themes of corporate rights and corporate accountability and corporate power in a democratic society.